Hello and welcome back to Coin Lady channel. Earlier today I released a video in which I mentioned the possibility of a jury trial. In the SEC versus Ripple case, this was theoretically always a possibility. It was less plausible before Judge Torres's ruling, but now it is more probable. A lawyer for the XRP community, Fred Rispoli, believes that the issue between the SEC and Ripple will not be resolved until 2024 if a jury trial goes forward, which seems more likely at this moment. Sadly, I can't even joke around here. If it were up to me, that would never happen. As you may have guessed, I don't enjoy being the bearer of terrible tidings. You know what though? When circumstances are good, I want to be your companion, and when they're bad, I want to be your companion. So, whatever occurs, it's fine. Do not assault the bearer of bad news. Nonetheless, I'll fill you in on the details, feedback, and additional. It's not all the information I have on the subject, but I do have what I needed from the lawyers I consulted. And there's another tale I'd like to tell you, one that's equally fascinating to me. While it has been covered by every crypto news outlet known to man, this one originated at Decrypt. The headline, however, is as follows. Notwithstanding Gensler's Bitcoin-only stance, the CFTC chair has declared Ethereum to be a commodity. To add insult to injury, many of you will remember that Kim Jong-Gensler declared everything other than Bitcoin to be a security late last month. And now you have the CFTC chair saying, whoa, 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 whoa. Just shut the hell up. I don't even know what you're trying to say. Because they have monopolized Ethereum for so long. There's really no room for argument there. Now, let me explain it to you. But there is something I need to clarify before we go any further. No, I don't come from a financial or legal background. There is no recommendation to purchase or sell based on anything I say or write, and I am not a licensed attorney or financial advisor. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. An example of this is a piece by Crypto titled Ripple Whales Migrate. More than 100 million XRP and USEC trial is likely, according to the attorney. And some of the topics discussed here are the same ones I wrote about. You may have seen this on your screen before, but just yesterday there was a tweet from a former attorney and current member of the XRP community named Scott Chamberlain, in which he had this incredibly intelligent thread, and I posted this little portion of it. This decision leads to divergent expert testimony, which makes it difficult to apply for summary judgment, making trial more likely. That was tweeted by Scott Chamberlain, and I'll add that attorney John Deaton retweeted it and agreed. As of right now, he believes that Attorney General Deaton is leaning towards a trial by jury. And this seems to be and by the way, if anyone is asking why hadn't attorneys inside the XRP community explored this more deeply, it's because of this. Okay, I'll get there eventually as well. Nevertheless, a tweet from a community member named Big Lemon who said, I feel like settlement may actually be on the cards right now, was what sparked this discourse today, technically the previous day, and then again about 5 hours ago. And of course, that's in response to the ruling we saw a couple days ago from Judge Torres, which was clearly pretty heavily in favor of Ripple and not so good for the SEC because they're expert witnesses on the most important points that they needed to make that's not even being allowed in the case. Clearly, Judge Torres is not on board. However, XRP community member and attorney Bill Morgan retweeted that and confirmed it was still possible as of March 2018. To be honest, this has always been a possibility. The possibility that Judge Torres will force the case to go to trial has been discussed, and if that happens, a ruling regarding secondary market sales of XRP could be issued, suggesting that the proceeding will not be directly related to that issue. In that case, you might be left wondering why Ripple would bother with the trial at all. For the simple reason that this is where Ripple runs into problems. Why wouldn't Ripple settle if Judge Torres rules that out of the question? This is also something to think about. I don't want a jury trial, even if it's possible one could happen next year and would be terrible. Why not, even if that's the case, if you're Ripple? Right. You can be assured that your XRP transactions are completely safe, so go ahead and do a check of any quantity you like. Theoretically, at least. And so, that settles it, we now have a recognized citizen of the community. writer who expressed the desire that Attorney Morgan would take the time to read his feedback, which he did. I was wondering how long the trial would last if it came to that. A lawyer. How long till the trial begins? Morgan asked back. Or how long does it take to finish? As the trial begins, what do you anticipate will happen? Dr. Fred Rispoli just there, he tagged him. I'm not familiar enough with the local court lists and scheduling to make an educated guess as to when a trial might be heard, but I imagine it would be put on hold for very some time after it begins. After then, Fred Rispoli, an attorney, steps in. Moreover, Fred, as a friendly reminder, Rispoli is currently suing Coinbase on behalf of the XRP community due to Coinbase's failure to deliver the Songbird token and Flare tokens. Coinbase still hasn't turned it over as of March 2023, and they don't appear to have any plans to do it, at least not with the Songbird coins. It is said that they will provide you the Flare tokens. So he's suing them, and I fully support him doing so, since I find Coinbase's treatment of its users in our community to be totally intolerable. As for when the trial would take place, attorney Fred Rispoli remarked, I would be very shocked if trial could take place before 2024, estimating that it would take between 30 and 40 trial days, or roughly 2.5 months. Okay. Nevertheless, at least the trial wouldn't go horribly wrong or take too long. So if we're talking specifics, entering the year 2024 and then waiting 2.5 months. My goodness. What, then, will it entail for us between now and, say, March of next year? Also, there may be further appeals if necessary. You do realize how lengthy this is, right? I mean, you really feel like banging your head against the wall, don't you? Whatever it is, I just want it to end already. Now, I still believe it is more likely that a way will be found here to avoid that. In any case, it's not completely out of the question. Afterward, a community member named Brian Monarch tagged me and said, trial probably won't even start until 2024, followed by an eye roll emoji. And I appreciate you tagging me, Brian Monarch. I value your thoughts and opinions and agree with them. Oh no, I thought when I saw that. As an added bonus, I value Rispoli's input. There's just no comparison to that here. It's so frustrating that all you can say is damn it over and over again. I can't believe it. Oh man, I sure hope not, I told him in response. A jury trial is something I've always assumed would begin this year, but Fred would know for sure. Lawyer Bill Morgan wrote back to tell me he thought this year, or at least hoped this year, but he didn't know enough about the local makeup of this court's judge lists to make an educated prediction. I was not shocked by his estimate of the number of trial days needed. This piece was based on my internal monologue. And then there was an extra community member named Van Hazen, who wrote to Bill Morgan, and he said, my question is why now so close to summary judgment? It sounds like you guys are really pushing for this to get to court. Even though it could have ended in summary judgment, I don't see why the crowd couldn't have been informed and ready for that possibility much sooner. If this is now the most likely outcome, what changed? You know what else? That's a reasonable inquiry to make. I've seen this topic brought up several times by the lawyers I follow in the XRP community. But it can't be denied that this hasn't been a major concern. Despite the fact that I agree with him, I think he's missing the most recent and significant development by a few of days. Because of the decision made by Judge Torres. Hence, I simply answered him, telling him that the recent judgment by Judge Torres had altered the playing field. Clearly, the level of disagreement over the facts has increased to the point where a jury will likely have to decide the matter. An SEC expert witness, for instance, will be able to testify that the XRP ledger is not truly decentralized. Furthermore, and you already know this, although I personally believe this to be a straw man argument, I do agree that both sides should be given the opportunity to present their case and have an opposing tech expert justify why the XRP ledger is truly decentralized. Judge Torres's actions make sense to me now. It's just that, from where we're sitting, this all seems like such an apparent falsehood that our eyes are starting to glaze over. It's blatantly false. I know. Okay, we get it. Okay, we get it. Nonetheless, for summary judgment to be granted, there can be no genuine issue of material fact. It's simply a matter of determining how to apply those facts in light of the law. This is a disagreement over verifiable facts, which is why I gave an example. Can you explain whether or not the XRP ledger is centralized? If a judge or magistrate cannot decide the matter, a jury trial will be necessary. And so, we shall see. Perhaps even beyond the year 2024. Well, I valued it so much. If the SEC lawsuit doesn't go to court in 2024, I swear to God I will pluck out all of my hair from filming about it. To put it another way, I will carry it out. Let me take care of that for you. Yes, I plan to show up. Still, I can't bring myself to do it. In any case, here's what it is, I'd rather be talking about something else on my channel. For what it's worth, then, here's a headline from the crypt. Go to the next subject. Notwithstanding Gensler's Bitcoin-only stance, the CFTC chair has declared Ethereum to be a commodity. As a result of the SEC's gradual expansion of its authority over the digital asset market, the head of the Commodities and Futures Trading Commission has adopted a forceful stance against it. It was reported on Wednesday by Rostin Bainum of the Senate Agricultural Committee that Ethereum, the second largest cryptocurrency behind Bitcoin, is a commodity. It has been traded on CFTC-regulated exchanges for some time. According to Bainum, this gives the agency direct jurisdictional hook to regulate the derivatives market as well as the underlying market. Gary Gensler, chairman of the Securities and Exchange Commission, claimed last month that all digital assets, including Bitcoin, are securities. His view seems to directly contradict that position. Even while he has been careful to avoid direct references, Ethereum's shift to a proof-of-stake consensus method has led the chairman to repeatedly imply that his statement applies to that network. Even if I'm pro-ETH, not because I'm really enthusiastic about it, but it is a big component of the cryptocurrency ecosystem, it is wonderful to see the tiny amount of opposition from another party. From last November, 2017. I've been keeping it. Indeed, I have this very token, which was the very first cryptocurrency I ever bought. You should know that it would make me happy if that didn't end in failure. That's why it's encouraging to see people speaking out against the SEC. But it has been quite evident for quite some time that it will come under threat. In fact, on September 15 of last year, when Ethereum was released, it was more apparent than ever before. A headline from the website Decrypt: rather than relying on proof of work, Ethereum will now use proof of stake. Have a peek at the headline. The much-anticipated merging event on Ethereum has been completed, marking the beginning of the proof-of-stake era. You should abandon proof of work in favor of proof of stake. That's a huge deal. Here's another piece I deciphered from the headline from September 5, 2022. The proof-of-stake assets, according to Gensler. Possible securities report. So, it's a baby, I guess. It's a coincidence that Kim Jong-un takes power on the same date Ethereum, after years of planning, finally makes the switch to proof of stake. For this reason, he consistently avoids mentioning Ethereum. In contrast, he claims that asset proof of stake can be protected. He must have been scheduled for that day by sheer coincidence. True, it's a big, fat coincidence. Methinks. No, not that son of a whore. I don't claim to be an expert on money matters. None of what I say or write should be used as a basis for making any financial transactions. That's a horrible concept. It's all over today. Please like and subscribe my channel. See you later, bye.